3, 2, 1, start. But there was no railway line adjacent to the disputed land which could have caused a fire stop even otherwise, the rent notice exhibit 1 does not refer to the plot in question, and its boundaries have also not been mentioned. Merely on doubtful material and cursory evidence, it cannot be held that the plaintiff was ever in possession of the property, and that two in settled possession. The plaintiff, respondent number 1 makes much of the old body of a motor vehicle belonging to him lying on the property. Exhibit 2 clearly reveals that one part of the motor vehicle was lying on the disputed property and another part was lying on the plot of the plaintiff. The said body of the motor vehicle is about 3 to 4 feet in length only, and the same was lying on the boundary of the disputed property. But the plaintiff respondent number 1 claims possession of the entire plot based on such a fact. Absolutely no material is found to show that the plaintiff respondent number 1 was in actual possession, much less continuous possession, of the property for a longer period, which may be called settled possession or established possession. As mentioned supra, mere casual possession, that two relying on a motor vehicle body lying on a part of the property, would not prove settled possession of the plaintiff. The plaintiff has to prove his case to the satisfaction of the court. He cannot succeed on the weakness of the case of the defendant. Even otherwise, there is no confusion at all regarding the identity of the property in question, and on the basis of material on record, the first appellate court has correctly ruled that the appellant defendant number 1 has proved his title and possession over the suit property since the date of his purchase of the property. Prior to the purchase, his predecessor in interest was in possession of the same. Having regard to the position of law and facts of the case, we are of the considered opinion that the High Court was not justified in interfering with the judgment of the First Appellate Court, which has come down very heavily on the procedure adopted by the trial judge in deciding the matter, more particularly when no fault can be found on the facts with the judgment of the First Appellate Court. Generally, it is not open to the High Court to interfere with the findings of fact recorded by the First Appellate Court when such findings are based on the evidence on record and are not perverse or against the material on record. The conclusion arrived at by the High Court and the reasons assigned for the same are not correct, inasmuch as there is absolutely no material in favor of the case of the plaintiff to show possessory title. In order to claim possessory title, the plaintiff will have to prove his own case and also will have to show that he has better title than any other person. Since there is no documentary proof that the plaintiff was in possession of the suit property that two for a long period, he cannot be allowed to succeed based on minor discrepancies in the evidence of the defendants. Accordingly, the appeal succeeds and is allowed. The impugned judgment of the High Court dated 28 8 2006 and its review stands set aside and the judgment of the first appellate court is restored. Stop. Consequently, suit stands dismissed. Stop. Over.